I just want to address one thing today. I hear this statement a lot. My parents went through probate. It wasn't that bad. And I hear that a lot. My name is Philip Roos. I'm an estate planning attorney here in Minnesota. And I hear this statement a lot when we talk about probate skipping strategies when it comes to estate planning and asset protection. How do we avoid probate? We oftentimes use this thing called a revocable trust. There's other ways. And sometimes folks will say, you don't need that. Probate's not that bad. And I agree that in Minnesota, we don't have the nightmare probate system that we have in some other states. If you go to New York, California, Florida, it can cost $50,000 to get through probate. Minnesota's not like that. I always tell folks to prepare for something less than $10,000. We're always hoping it's closer to $5,000. Sometimes you get an extremely straightforward probate that's less than that. I would not count on that. But the statement itself, probate is not that bad. That implies to me that it was bad. It just wasn't that bad. I've never once had a family go through probate and say, wow, that was fantastic, let's do that again. No one likes it, universally. Nobody likes probate. It's always at the minimum a big pain in the butt. If it's not that bad, you're just saying that it's bad. It just wasn't, that bad. I don't know. It always strikes me as kind of a funny phrase. But again, if you don't care about probate, if you really don't care about it, there's nothing saying you have to skip it. But what you do want to do is you want to make sure you're at least controlling it. So if you're not going to try to avoid this court process, probate again, it's the administrative court proceeding where if I die, my stuff gets divided up. We got to have someone who's empowered to sell the house. We have to have someone who can get my bank accounts, pay my medical bills, okay? If we go to probate, and you have no documents, we use Minnesota's backup rules. They're called the intestacy statutes, Hard to say that, intestacy statutes. The intestacy statutes are the government plan for you. There's already a plan set up by the legislature. We don't want that plan, we want your plan. So at the minimum, you must do a will to guide the court through the probate process. A will is a court document that controls probate. It overwrites those default rules with your rules. And that's what we want. So at the minimum, if we are okay with the expense, time, and publicity, the public nature of probate, you still want to make sure you're doing a will. Make sure it's valid, make sure it has all the probate rules in it. You don't want a one-page will, that's usually not a good time. It has to have your backups. If this person can't administer the estate, this person can. If something happens to this person, this is who gets the money instead. You want to have all that stuff built in there and make sure that it is a thorough, legal, and administratively workable will document at the minimum. If you're looking to avoid it, there's strategies for that as well. Any questions, please do give me an email. My name is Philip Roos at Stoneworks Law Office.